West Valley group and is the legislation chair and updates everybody in the PIRA group about HR topics. And she did this presentation earlier last month to the PIRA group, and I thought it was really important that our clients and friends of ours receive the information. It's very good information about exempt and non-exempt employees and also about independent contractors. So Sherry, I'll just turn it over to you and I'll interject as little as possible.
Great, thanks Barry, and thank you for inviting me to do this presentation to your clients. I really appreciate it. I don't know how many of you are here in Southern California, but it's a pretty gloomy day today, so it's a good day to enjoy a webinar presentation. So today we're talking about, well, I'm still getting an echo, but it's kind of weird. I'll try to ignore it. Today we're talking about avoiding the pitfalls of FLSA misclassification. And before I start, you have a chat box at the bottom of your screen, and if you have any questions throughout this presentation, please feel free to send questions, and I will try to get to each of your questions and hopefully provide intelligent answers to them. When we start here first, I kind of want to get to know you guys a little bit. How many of you have employees outside of California? You can just write a message in the chat box and let me know. Okay, so we do have a few people who have them. For those of you who don't, you may be wondering why you even signed up for this webinar, because you're thinking, I'm in California, so why do I care about the federal law? Because California, there's a question of whether Barry's mic is picking me up.
Okay, based on that, what I'm going to do is turn off my mic and mute myself. Angelica, thank you very much. I'll try that.
Did that work? Oh, now I don't hear my echo. Awesome. Okay, so so let's go back. So why do we care about the FLSA here in California? Because generally California's laws are much more employee-friendly than the FLSA. And when I first started to put this presentation together, I was putting it together back in the September-October 2016 timeframe, and that timeframe is important because at that time we didn't know who was going to become President of the United States, and we had the Department of Labor, as most of you know, proposing to increase the salary requirements for exemptions under the FLSA. Well, lo and behold, since then, of course, that did not happen. It's still out in limbo right now, but most of us think that that issue is pretty much dead. Although there is a bill pending in California right now to actually mimic what the Department of Labor was trying to do, but we'll see what happens with that, and this presentation doesn't really talk about that issue. But there are other reasons to make sure that you are complying with the FLSA. One is that even though we're here in California, we are still required to comply with federal law. So anytime the FLSA has any part of its law that is more generous than California law, then we still need to comply with it. And then of course, for those people who have employees outside of California, this is germane to you because most other states do follow the requirements of the FLSA. The other reason is that, believe it or not, California actually often does follow the FLSA. Many of the laws and IWC wage orders that we have here refer directly to the federal law and the federal regulations that are associated with the FLSA. So it's important to understand what the FLSA is about and the exemptions that are under that particular law to help us figure out whether we are even compliant here in California under California's law. So I wanted to just give you a little bit of a perspective here too. So the FLSA, as you may recall, was enacted back in 1938 during the Great Depression to encourage employers to hire more employees. And so it was to tell employers, well, you're going to have to pay people a certain amount of money, and if you have them work more than 40 hours, you can, but you're going to have to pay them more money, as opposed to hiring extra employees where you could pay them less money to work those extra hours. So it was sort of to get out of the Depression and to increase employment, it was a way to do that. But keep in mind, though, when the FLSA was enacted, think about the types of jobs that existed back in 1938. We didn't have computers, or very little computers. We did not have smartphones. We did not have telecommuting. We did not have all of the modes of transportation that we have now. There's a lot of different types of jobs that we have now that just did not exist back in 1938. And while there have been some updates since then to try and keep up with the times, our legislature is not particularly known for keeping up with the times, and so it becomes very hard sometimes to figure out whether jobs that we have today, how they fit within the rubric of the FLSA. And that's why it is so challenging. On top of it, the exemptions are narrowly construed. So that means that you have to assume that somebody is a non-exempt employee, and it's only if they fit within those little categories that they are actually going to be exempt from the law. And it is also the employer's burden to prove that they're exempt. So we always assume that they're non-exempt, and then the employer has to have the evidence and the backup to show that somebody is actually truly an exempt employee and is not entitled to overtime. These issues are very factually driven, and so it's very difficult in litigation to get out of these cases in an early stage of the litigation, what we call summary judgment, which is when we present to the judge, okay, judge, even if you believe everything that the employee says, they still have no case. In these types of situations, there's a lot of questions as to, well, how much time did they really spend on this particular duty, or how important was this duty versus the other duty in their particular situation. And those types of specific facts often require somebody to make a decision, whether it be the judge or the jury. And so these types of cases can often lead all the way down the road to trial unless the parties decide to settle. This issue is also very important because it's very expensive, not only for the legal fees that you pay your own lawyer in trying to fight these cases, but also the potential damages that your company can be exposed to if you are found to have misclassified an employee. Those damages can include, under the FLSA, up to 3 years of back pay. Sometimes it's 2, but it can also be 3. Also liquidated damages, which is 2 times the amount of back pay. There are other statutory penalties. In California, there's also civil penalties, or that dreaded PAGA that we hear about. You also can be required to pay the other side's attorney fees in these types of cases. So to the extent that you see these bills from your lawyers, just imagine having to pay double that because the attorneys on the other side get paid when they win these types of cases. If that's not enough to scare your C-suite, you can also tell your executives that there is potential personal liability for corporate officers and supervisors who willfully violate the FLSA. So if your CEO or other C-suite member is resistant to looking at reclassifying your employees, just remind them that if they don't look at it, that they could be personally held liable. Now let's talk some real numbers here as to what that means. So these are some examples of some recent settlements that have happened regarding misclassification. Some of these have to do with independent contractor misclassification, and others have to do with misclassifying somebody as exempt when they're really non-exempt. So for instance, we've been hearing a lot about the gig economy, and we have Lyft and Uber. So we have Lyft here who recently settled for $27 million just for their California drivers. That was just in California. Uber, they tried to settle in California for $84 million. That settlement was rejected by the judge. The judge thought that it wasn't enough. And that related a lot to the California PAGA penalties, but this shows you just how much money we're talking about, that even a judge didn't think it was enough money in that case. Going to some more traditional jobs, we have FedEx for delivery drivers. They settled recently for $228 million just in California. And then they also settled for another $240 million in 20 other states for their delivery drivers. This also shows you an example of how much more it costs to settle cases in California than in other states, because we basically have a 1-to-20 ratio here. We also have Morgan Stanley that settled for $50 million for their financial advisors and brokers. TD Bank, $9.9 million for their assistant managers and banks. Walmart, they have their vision center managers and asset protection coordinators. They sound like very high-level, fancy positions, but they ended up settling those for $5.2 million. Yelp for their account executives, their salespeople, $1.25 million. And I just wanted to throw in a retail because I wasn't sure what types of businesses everybody's in, but we have City Gear that settled for $2 million for misclassified retail store managers. So what I want to do today is go through first the law itself and explain what the FLSA is and what it isn't, and what the various exemptions are. And then we're going to talk about some of the different tests with employees versus independent contractors. When is somebody an independent contractor, and when are they an employee? Also, we're going to talk about how to determine the proper classifications and some ways that you can and methods that you can use to determine whether they are properly categorized as an exempt employee, non-exempt employee, or independent contractor. Also, to help you with your current situations, I'm going to provide you some tips on some warning signs of when you may actually have some misclassifications in your organization, and some common mistakes that are made that hopefully you can avoid. So let's start with the law. So what does it mean to be exempt? We use the word exempt sort of off the cuff a lot. We say somebody is an exempt employee. We say somebody is a non-exempt employee. But what does that actually really mean? What it means is that you are exempt from the laws, the minimum wage laws and the overtime laws. So that means you do not have to pay somebody the minimum wage, although in most cases it's more than the minimum wage, and you also do not have to pay them overtime. So what we're saying when we say exempt is that they are exempt from these particular laws, and that works both in California and under the FLSA. Traditionally, the blue-collar production workers are always considered non-exempt. So any production workers that you have right now that are on salary, you need to relook at that, because they should always be considered non-exempt. The FLSA, though, has what's called a white-collar exemption test. So for those white-collar jobs that satisfy particular requirements, they can be exempt from being paid overtime. So the first thing is that they have to have a minimum salary level. And under the FLSA, the minimum salary is $455 a week, or $23,660 a year. And that's really about half of what California currently requires. This was the area that the Department of Labor was looking at raising because this salary level has been in play for a very long time. And just based on economics and the increase in the standard of living, they were looking to increase the salary level requirement for those exempt jobs. And for a few, even if those had gone through in California, it still wouldn't have affected California for a few years because our minimum wage is so much higher than on the federal level. So on top of being paid a certain amount of salary, you also have to have a primary duty that falls under one of the exemptions. Now, this is a key area that is different between California law and federal law. Under federal law, we look at primary duty in terms of a qualitative analysis. So we look at the principal, major, or most important duty that is being performed by the employee. Under California law, they focus more on what's called a quantitative analysis. So not only do we look at the particular duty, but we looked at the duty and how often you perform that duty. And you generally need to perform that more than 50% of the time for it to be, if it's an exempt duty. Here, there's no quantification in terms of how often you perform the duty. It's more an issue of whether it is the principal part of your job. And the duty can be concurrent. So you can sometimes have people doing an exempt position or an exempt duty and also be performing a non-exempt function at the same time. So for instance, if you have, let's say, a supermarket, and you have a store manager at a supermarket who's in charge of overseeing the baggers and making sure that they are performing their jobs correctly. And as they're walking the floor, they notice that there is a spot where somebody is missing a bagger. And so they come over and they start bagging the groceries. Now, are they performing a non-exempt function? Absolutely, because they're bagging groceries. But at the same time, they're performing an exempt function because they're also observing to figure out why that position is not, there's no bagger there at that particular time, and they're making sure that the customers continue to be happy. And those would be more on the exempt side of things. So it would still be considered an exempt job in that particular scenario. So now I'm going to talk about the particular exemptions under the FLSA. The first one is the executive exemption. And under this exemption, the primary duty is to manage an enterprise or a customarily recognized department or subdivision. So what that means is you cannot just arbitrarily create a section of your workforce and put somebody in charge and say, okay, this person is an executive. So let's say you're a widget factory and you make blue widgets and red widgets. And we're saying, okay, blue widgets over here, red widgets over there, and we're going to have somebody, the quote manager of the blue widgets and one of the red widgets. Well, they're all widgets. They're all being manufactured. It's an arbitrary designation, and it's not a recognized department or subdivision, as opposed to your entire production facility. And if you have a manager in charge of your entire production facility, that would be a recognized department or subdivision. So you have to look at exactly what it is that they are in charge of to see whether it'll pass basically the smell test. The executive also must customarily and regularly supervise 2 or more full-time employees. And what it means to supervise is that they either have to have the responsibility of hiring, firing, or changing the status of employees, or they have to be able to effectively recommend those changes. So often organizations do not allow people to be hired or fired without HR approval. A smart idea. And if that's the case, that's okay. That does not destroy the exemption, because the manager, as long as the manager can say to the HR person, hey, I think this person should be fired because of X, Y, Z, and then HR reviews it, says, yes, you're right, okay, let's go ahead and fire him, that's an effective recommendation. As opposed to a low-level employee who may say to their manager, hey, I'm noticing that so-and-so keeps coming in late for work. Shouldn't we do something about it? And then it's up to the manager to make that decision whether to discipline the employee. The other person who made the complaint is not considered to be an executive, because it's not an effective recommendation. That was just a suggestion to his manager. So some of the examples of the executive exemption functions, these are listed in the federal code, and I'm going to go over, I'm going to list them, and there was too many of them to put in the PowerPoint here, but you can always look them up in the federal code as well. It includes interviewing, selecting, and training employees, setting and adjusting rates of pay and hours of work, directing work of subordinates, maintaining production or sales records for use in supervision or control, appraising employee productivity and efficiency for purposes of recommending promotions or other changes in status, handling employee complaints and grievances, disciplining employees, planning and determining techniques to be used in one's work, apportioning work among employees, determining the types of materials, supplies, machinery, equipment, or tools that need to be used, merchandise to be bought, stocked, and sold, controlling the flow and distribution of materials or merchandise and supplies, providing for the safety and security of employees or the company's property, planning and controlling budgets, and monitoring or implementing legal compliance measures. So, yay, HR people, if you're in charge of making sure the legal compliance is in there, you get to be an exempt employee as long as you meet all the other requirements of this particular exemption. Does anyone have any questions about this particular exemption? I don't see any questions, so I'm going to move on to the administrative exemption. Now, the administrative exemption, this one is a little more tricky. It's not as easy common sense-wise to figure out. But in this particular, and there's a lot of litigation over this one, but in this particular one, the primary duty is that you're performing office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. And you must also have discretion and independent judgment regarding, quote, matters of significance. So if you're, again, if you are on the production side of the organization, you are not going to fall within the administrative exemption. This is basically the people who are running the business side of things. So, for example, your tax professionals, your finance department, accounting, budgeting, strategic planning, insurance, quality control, purchasing, advertising, legal compliance, and yes, human resources. These are the types of jobs that you traditionally see in any company to help run the company, as opposed to providing the service or goods that the company provides, which would not be part of the administrative exemption. And then on top of it, you have to be at a high enough level that you are making decisions that are, quote, matters of significance. So, for instance, if you have a buyer in your organization that makes a decision as to whether you're going to get felt-tip pens or ballpoint pens, your CEO may think that's important, but really is not a matter of significance in terms of the operation of the company. You have to have a higher level of decision-making authority to be able to fall within this exemption. So in order you cannot be strictly controlled by management with narrow discretion and not be involved in making judgments or committing the employer in significant matters independent of the individual supervisors. And if you don't have a significant role in developing the core business strategy, then often you are not going to be considered an administrative, under the administrative exemption. Okay, next is the professional exemption, and there are two parts to the professional exemption. First is the learned professional, which is having advanced knowledge in a field of science or learning customarily acquired through a prolonged course of specialized intellectual instruction. In other words, you need to have a master's or a doctorate or a higher level, usually a higher level than just a bachelor's degree. There are some bachelor degrees that do qualify for the learned profession. So for instance, nurses, I believe they just receive a bachelor's degree in nursing, but because that is a specialized area, the bachelor's degree is sufficient for this. Keep also in mind that this does not require that you actually have that higher level degree. It says here that it is customarily acquired through a prolonged course of instruction. However, there are times that either through job experience or otherwise that you may reach that same level of expertise as somebody who has that degree that could still qualify for the professional exemption. Many people don't know this, but you actually can become a lawyer without going to law school. Shocker of all shockers. I did go to law school, I promise you, but it's rare. But you can, if you get a sufficient education and are able to pass the bar, you do not necessarily have to graduate from a accredited law school in order to be a lawyer. So there are times when you could fall under the professional exemption and not actually hold that high degree. And Robert, I'll get to your question in just one moment. Let me just go through the second part of the professional exemption. The second part is the creative professional. This is the person who requires invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. So these are your authors, your artists, your actors. Those types of individuals would fall under the creative professional. So I have a question here from Robert. He's asking, what exposure does an employer have if it pays an obviously non-exempt employee via salary? The employee is being paid well above the minimum wage. Is there an acceptable strategy to pay a non-exempt employee's salary? So a non-exempt employee can be paid on a salary basis, but they still need to be, that salary has to reflect only the standard amount of hours. So if it's a full-time employee, it would be for 40 hours of work. And then if that employee works more than 40 hours, then they still would be entitled to overtime based, and you would figure out the regular rate based of the overtime pay based on the salary that you are paying the employee. So non-exempt employees can be paid on a salary basis as opposed to the other way around where exempt employees cannot be paid on an hourly basis. They must be paid on a salary basis. But the flip side is not necessarily true, although it becomes a little more complicated. And then I have a question here asking, would nurses or physician assistants in a medical practice be considered professionally exempt? I'm going to use a lawyer answer for that, which is it depends. You would have to look at the particular jobs that they're doing and what type of medical practice we're talking about, whether it's a hospital or a doctor's office. There are different requirements under California law as to whether they are considered to be exempt or non-exempt. I think physician assistants usually are non-exempt. Because they don't usually have those higher degrees that a doctor or a nurse would have. And then we have a question of whether mechanical and electrical engineers fall under an exemption. They can. Again, it depends on what they're doing, they could fall under several different exemptions. They could fall under the professional exemption as a learned professional if they have a higher engineering degree. Then they could fall under that exemption. They also could possibly fall under the manager, the executive exemption, if they are overseeing other engineers or other staff members and they are doing executive type duties, then they could fall under that exemption. So again, for each particular role, it really does depend on the facts. And in terms of the professional exemption too, it has to be related to what you are actually doing. So for instance, I have a law degree, but if I go work as a data entry person at a location, I'm not going to be considered an exempt employee just because I have a law degree. I would still be considered non-exempt because of the actual duties that I am performing. So the question here is, an exempt employee can be paid on an hourly basis as long as the overtime rule is enforced. I think you meant a non-exempt. An exempt employee cannot be paid on an hourly basis. They must be paid on a salary basis. I hope that answers your question, Robert. If not, keep typing and I'll try to keep on answering to clarify. These are great questions, by the way. Thank you very much. Okay, I'm going to move on now to the outside sales exemption. This is your typical outside salesperson who primarily makes sales or obtains orders and contracts, and they are customarily and regularly away from the employer's place of business. So they are out pounding the streets, going out and doing their sales outside of the business location. These are not your inside salespeople. That's a different issue. These people have to be generally outside of the workplace, going out and making presentations and sales and gathering orders or contracts. And this is important that it doesn't necessarily have to be that you're selling a good. You can just obtain orders or contracts. So for instance, if you are in the healthcare, if you're with a pharmaceutical company and you're going out and selling pharmaceuticals, obviously you can't just sell the drugs, but you can obtain orders or contracts or encourage people to use those particular drugs or to convince the doctors to prescribe those particular drugs, and they could still be considered outside salespeople even though they can't legally sell the drugs. I have a question here, is whether a part-time CPA can be an exempt employee. Yes, part-time employees can be exempt as long as they meet that salary requirement. So in California, of course, it's a little bit higher than on the federal level, but a part-time, it doesn't matter how many hours you actually work. You can, if you meet the salary requirement and the duties requirement, you can be an exempt employee. Okay, now we're going to go to the one area where Congress did go into, well, maybe not the 21st century, but they got close to it, and they added a skilled computer exemption. Now this is the one exception in terms of being paid on a salaried basis. You can be paid on an hourly basis for your computer professionals, but it's a much higher hourly rate. You have to be paid at least $27.63 per hour. But in California, it's much higher than that. Right now, the salary requirement is adjusted every year for the computer exemption in California. Right now, for 2017, the hourly rate is $42.35, or it's $88,231.36 per year. So make sure it's not 35 cents per year. You've got to pay at least that 36 cents. So this is the one exemption, or the one exception to that salary requirement. but not all computer professionals do fall within this exemption. Only people who are system analysts, computer programmers, software engineers, or other similarly skilled workers in the computer field. And their primary duty is to apply systems analysis techniques and procedures, or design, develop, document, analyze, create, test, or modify computer systems or program based on user or system specs, or a combination of those functions. So your computer professionals that go out and fix people's computers, they do not fall within this exemption. This is mostly your programmers and the people that are designing and developing the actual products that you are creating either for your company or for a particular customer. So functions such as training customers to use software, or installing, debugging, troubleshooting, and converting data and testing customer equipment, those are generally not exempt functions, and so those types of individuals, if that is their primary duty, will not fall under the computer exemption, even if they're being paid that high-level salary. Now this is the commission salesperson. This is now talking about your inside salespeople. Under the FLSA, this is a very narrow category. Not all inside salespeople, or what you might think of traditionally as inside salespeople, qualify for this exemption. You must be employed in the retail or service establishment. So this is talking about like your, let's say, a furniture store or a clothing store. Those type of establishments, you can fall under this exemption. But other types of industries, such as your financial service industry, insurance, things like that, are not included. Also, I have a list here of a lot of other ones that are not included under this particular exemption. And under this exemption, you also have to pay 1.5 times more than the federal minimum wage for this particular exemption. So you have to be slightly higher, although again, this is still way under what California requires. So for your California employees, that threshold is not going to make a difference. Now the FLSA has another exemption called the highly compensated employee exemption. Unfortunately, this one is not available in California. So for those of you who only have California employees, you can go take a stretch break. But for those of you who have employees outside of California, you might want to consider and see whether you have employees that don't quite fit any of the other exemptions, because the duties that they're doing don't quite fit within those small boxes. But they are still a very highly paid person. So if you are making a minimum salary of $100,000, and that can include commissions and bonuses and other non-discretionary compensation, and if you customarily regularly perform any one or more of the exempt duties of an executive, administrative, or professional employee, then you might be able to qualify for this highly compensated employee. So for instance, you may have an executive that is paid a lot of money, but they only supervise one person, their assistant or something. So they don't quite technically qualify for the executive exemption, but they make high-level decision making. They can hire and fire that employee, and they make executive decisions. Then they might qualify for the highly compensated employee exemption. But again, this is only for outside of California, not within California. There are also some minor exemptions in the FLSA that also are not applicable in California. There's some exemptions for agricultural and domestic service employees. These do not apply in California. We have wage orders that cover these individuals. And there's also some ones where the overtime exemption doesn't apply. The minimum wage does, but the overtime does not. These, again, are generally not applicable in California, but for some reason, movie theater employees, I have no idea why, but they are exempt from overtime outside of California. And then there's other employees who are covered by other federal acts that govern their wages and overtime laws, such as the Motor Carrier Act and the Railway Labor Act. And so to make sure that there's no clash between the FLSA and these other acts, they are exempt from the FLSA, and then they're covered by other federal provisions. Now, one of the biggest issues and one of the most highly litigated issues in California and outside California is whether somebody is an employee or an independent contractor. If there is any doubt, you need to assume that they are an employee. That is always the default position. Employees are workers who are economically dependent on the business of the employer regardless of skill level. By contrast, independent contractors are workers with economic independence who are in business for themselves. And so that's where we get the word independent from. You have the independent contractors are independently earning themselves a living without any reliance on a particular business except their own, whereas employees are relying on the pay that they're receiving from their employer. Now, there's a lot of different tests, and I'm sure you've heard many different tests in terms of deciding whether someone is an employee versus an independent contractor. Here in California, a lot of times we look at about the control that an employer has over the worker, but that's only one of the issues on the federal level that they look at. The Department of Labor looks at what's called the economic realities and the totality of the working relationship. Those are nice, undefined, loosey-goosey terms that lawyers love because they can fight over what does that really mean. But the Department of Labor provides a list of factors that are looked at in determining whether someone is an employee or an independent contractor. So the first thing they look at is the extent to which the work performed is an integral part of the employer's business. And the litmus test that I like to use is if you put the person that you have classified as independent contractor and you put them next, if you have an employee who basically does the same exact duties as your independent contractor or the same exact work, they're not an independent contractor. They're your employee. If they're doing an integral part of what you actually do, they're making the same widgets, they're selling the same product, they are entering the same data as the employee sitting next to them, then they are really an employee and not an independent contractor. The DOL also looks at whether the worker's managerial skills affect his or her opportunity for profit or loss. So that really has to do with how much control does the independent contractor have in terms of its own pricing, whether they hire additional people to help them with a particular job, and whether their ability to make money is based on their own decisions as opposed to an employer just saying how much money you're going to get for particular work. There's also the relative investments in facilities and equipment by the worker and the employer. This traditionally means that the independent contractor is supplying its own supplies and equipment. So for instance, if you hire a painter to paint your walls, they're bringing their own paintbrushes, their own paint, their own rulers, their own tarps, then that traditionally would be more the independent contractor. Versus somebody who comes in and uses your computer and your Xerox machine and your pens and your calculator, then that is going to look more heavily towards that they are an employee. Also included is the worker's skill and initiative, how much independent business judgment they have, and whether they are competing in an open market and they are taking the initiative to operate as an independent business. So to the extent that they're competing for bids, They're doing sales pitches to you to convince them for you to hire them. Those are typical things that you would look at as being more of an independent contractor function. Also, the permanency of the worker's relationship with the employer. This is not necessarily going to make somebody an independent contractor, because you could hire somebody on a temporary basis and they are really a temporary employee as opposed to an independent contractor. But again, this is just one factor that the DOL looks at. So if you hire somebody for a particular job, going back to the painter, they're coming in just to paint the walls of a particular office and then they're going to be done and go on their merry way, then that would be a typical independent contractor relationship. And then, of course, what California looks at, the nature and degree of control by the employer. Whether the employer is setting the pay, setting the hours, how the work is going to be performed, whether that person can contract the work out to others, hire other employees to do the work. Can the painter come and hire some laborers to come in and help them paint the walls, or is it up to the employer to make that decision? This is not about telecommuting or having employees who have flexible hours. This really is more in terms of whether the person can determine how much time it's going to take to do a particular project. Some of the factors that are not considered is an independent contractor agreement. So you can have an agreement with somebody, a written agreement that swears up and down that somebody is an independent contractor, and have them sign on their mother's grave that they are an independent contractor, but that is not going to make them an independent contractor. They are going to look at what is actually being done, not the piece of paper that it's written on, but what is actually being, what is the job that is actually being done, and the various factors that I went over before, whether those are met or not in terms of whether someone is an employee or an independent contractor. Also, if you make somebody go out and get their own business license or to incorporate themselves, that does not necessarily mean that they are an independent contractor. Again, that's another piece of paper that says something, but it doesn't necessarily mean anything in substance. They're going to actually look at what the relationship is. And also the timing and mode of pay. So in California, sometimes you can look at whether somebody is paid by the job as opposed to being paid on an hourly basis or a salary basis, and also whether you pay somebody biweekly versus monthly versus when the project is done. Those are not necessarily going to weigh one way or the other in terms of whether someone is an employee or an independent contractor. Again, they're going to look at what the actual duties are that the person is performing and how much control there is, and so forth. Okay, now to the part where I'm going to magically tell you how to determine whether someone is properly classified, right? No. I'm going to give you some tips on how to determine whether someone is properly classified, but I certainly cannot here today tell you whether somebody is going to actually be properly classified as exempt or non-exempt. But these are some tools that you can use to help you determine whether somebody is properly classified. Let's see, hold on. Before I get to that, it looks like I have another question. So we have somebody who has advisors that work from home. They provide their own computer, internet, and phone equipment. The company sets their pay. The advisor sets their own schedule. The advisor is given within allowed topics. Hundreds of advisors work from home. A few dozen employees manage, support, and administrate from the corporate office. Are advisors independent contractors? I don't think that's something that I can answer in a 2-second call. I'd be happy to talk to you afterwards about this particular situation and kind of work through it with you to see whether these individuals would be independent contractors or not. But Angelica, one thing you may want to ask yourself is, are these people actually performing the work that generates the income of the company? If these advisors are producing the actual work of the company, then they are most likely going to be considered to be employees and not independent contractors. But we could talk about that offline. I'd be happy to. Barry could give you my contact information, or you may have it from the information, and we could certainly talk about that offline. Okay, so going back to determining the proper classification. So one of the things that's very helpful is a job description. These are not the be-all, end-all, but they are a good piece of evidence to be able to show whether somebody is an exempt or non-exempt employee. But you do want to make sure that those job descriptions accurately reflect the job that the person is actually doing. I don't know whether you've had the experience where you've gone through a job description with a manager and the manager says, oh, that's not what my employee is actually doing. So you need to make sure that those job descriptions are accurate in terms of what the person is actually performing and to be able to use them to determine whether someone is exempt or non-exempt. So don't just rely on the job descriptions. Go out and actually look at what the employee is actually doing. You can also conduct an audit of a particular job function or particular part of your organization, whatever needs to be looked at, and review not only your job descriptions, but any other documents that discuss the particular position or job. So you want to take a look at the recruitment ads that you may be using, any manuals that the employee has provided, or other policies that may include information about the particular job duties or the do's and the don'ts of the particular job duties that the employee has, to make sure that those don't discredit your position that something is either an exempt or non-exempt job. And you can also interview and survey your employees. Talk to the employees, because a lot of times the employees have a very different perception as to what their job duties are and what's important, the important primary part of their job, as opposed to the manager or a third party looking from the outside. It's important to get that input in knowing whether you might have some issues in terms of whether someone might be considered to be misclassified. When you do this audit, you may want to talk to your managers as to whether you want to have this done under the umbrella of the attorney-client privilege. The audit doesn't necessarily have to be done by an attorney, but you could have an attorney involved in the process and be directing the audit. That way, if it doesn't turn out the way that you liked, you can use the privilege to keep that under wraps. If you do the audit yourself, and if it's too close to call, I suggest that you get an independent third party to come in and provide a written evaluation. And the reason for this is not only to have somebody else come in to look at whether someone is exempt or not exempt, but also to have that independent written evaluation will help you with your what's called the good faith defense. So under the FLSA, I mentioned that you could either have 2 years or 3 years of back pay, and there's also additional potential liability if there's a, quote, willful violation. But if you have somebody come in and give you a written professional opinion that they believe that this particular position is exempt or non-exempt, that will be great evidence for you to show that you reasonably relied on an independent third party's advice as to whether somebody is exempt or non-exempt, and that might, even if they do ultimately turn out to be wrong, it could help minimize your potential damages. Now, if you find that a position is misclassified, then you're going to want to consider what options you have to rectify the situation and what the potential repercussions of that is. So if you find that somebody is classified as exempt but they really aren't, then you may want to consider increasing their salary or duties depending on what the issue is, or convert that person to a non-exempt position. But you're also going to want to look at what the potential repercussions of that is, how you're going to communicate that to your employees, so that it doesn't cause a complete ruckus in your organization or run them out to hire a lawyer. You're going to want to consider whether you're going to want to pay people some back pay during that period of time when they've been misclassified, to also minimize the potential of someone running out and filing a lawsuit or a DLSC charge or a Department of Labor charge. And you also want to think about your former employees too, because there is a statute of limitations. So here in California, it's actually 4 years. Under the FLSA, again, it's either 2 or 3 years. But there may be individuals who were misclassified that no longer are with you. And you will want to evaluate with your counsel as to whether it makes sense to go back and pay your former employees to minimize the risk of any of these former employees coming after you and filing a lawsuit against you or a class action and so forth. Okay, what are some of the warning signs of misclassification? Here are some typical issues that come up and are sort of red flags in terms of whether somebody might be misclassified. So if you have an organization where you have everybody is exempt, you have no non-exempt people, that's a warning sign that there may be some misclassifications in your office. For the same reason, if you have too many independent contractors, if all of your employees or all of the individuals that are creating your business are classified as independent contractors, that also could be a warning sign that they are being misclassified. Also, the administrative exemption gets abused quite a bit, and so you might want to relook. If you've got a lot of people classified in that administrative exemption, you may want to double check and relook at that. And just because a person's job title includes the word administrative does not necessarily mean that they are performing the duties that fall within the administrative exemption. So for instance, an administrative assistant who is mostly doing secretarial work or other non-exempt type work, just because it says administrative in there does not mean that they are exempt. So you want to look at those particular types of job titles. Those also can be warning signs. If your company has vague job descriptions, that also could be a warning sign, meaning that you're trying to hide all of the non-exempt duties that an employee actually performs if they're not listed in the job description. You want your job descriptions, and a job description, I could talk for another hour about job descriptions, which I'm not going to do here, so I'm just going to kind of make some general comments. But your job descriptions, you want them to be descriptive, but you also want them to be flexible, because your employees sometimes have to do different types of duties depending on the situation. So you don't want to box yourself too much in your job description, but you do want them to be sufficient to realistically describe what the different types of duties an employee is doing in their job. Also, low-level white-collar positions. So for instance, people who are leads or coordinators or supervisors, those individuals may not have duties that rise to the level of qualifying for either the administrative or executive exemptions. And so those are ones that get particular attention in litigation as to whether that person may be misclassified. Another big one, if any of you are in the retail industry, being a store manager or an assistant manager, this is a highly, highly litigated area. And so you want to take particular note of whether your store manager is primarily performing routine duties under the close supervision of a district or regional manager, or if there's someone who is primarily working independently, is paid more substantially than the staff, and is responsible for hiring and training and firing and scheduling and doing all of those exempt duties that fall within the executive exemption. Say another title that also can be a misnomer is the executive assistant. Often it's a very fancy title, but it could mean a lot of different things. An executive assistant could hold an administrative type function and fall within the administrative exemption, or they could be more doing traditional secretarial work, even if it is for your CEO, and they may be really non-exempt employees. Also, people who have occasional supervision or management, but it's not their primary duty, whether it's under the quantitative or qualitative analysis under the federal law or state law, those individuals would not be exempt. And also your IT computer positions, unless they fall within the particular job duties that I listed before, they are not going to be considered exempt employees. So some common mistakes that employers make in terms of when they make their decisions on how to categorize their employees or independent contractors. Please remember that it's the law who determines who is exempt, not the employer. So again, you can swear up and down, you can have in writing everywhere and every which way that somebody is an exempt employee or is an independent contractor, but it's the law that really makes the determination as to whether somebody is or isn't. You have to actually look at the particular duties that the person is performing in order to determine whether somebody is going to be exempt. When you communicate with your employees, make sure that they understand whether they are going to be exempt and are not going to be entitled to overtime. Employees who become shocked that they are not getting overtime are more likely to question why they aren't and go seek legal advice on those issues. Also, as we were talking about before, job titles and offer letters do not determine exempt status. Anyone can have a fancy job title. I hope I don't have anyone here in the banking industry, but everybody in the banking industry is the running joke that they're all vice presidents. But they're not all exempt employees. It's determined by what are they actually doing. One that I hear a lot is, well, but it's common industry practice to make this particular person an exempt employee or an independent contractor. That does not make you an actual independent contractor or an actual exempt employee. What it does is make you become a big target for plaintiff lawyers, because plaintiff lawyers will hit a particular industry and their common practice of misclassifying employees and come in and file lawsuits against every different company within that particular industry. That's why often you see particular industries in the news getting hit with these types of these cases. So for instance, like your retail store managers, that became a big one because people just assumed that store managers were exempt employees because they were store managers. But if their job duties did not have them meet the requirements of the actual executive function, then they are not actually exempt employees. Also, as we were talking before, being paid on a salary basis does not make you exempt. You have to meet those duties tests as a result also. Non-exempt employees can be paid on a salary basis or an hourly basis. But the reverse is not true. So if you are paid on an hourly basis, you cannot be exempt unless you are that one little exception for the computer exemption. Also, in California, just because you are highly paid, it does not necessarily make you exempt. You have to, again, also satisfy the duties test. So it comes up a lot in the financial industry, loan officers, financial advisors, stockbrokers, traders, all those types of people, unless they are doing specific duties that fall under one of the exemptions, they're highly paid individuals, but they are still non-exempt employees. And as was pointed out by Maria earlier, part-time employees can be exempt. So if it's a close call, I would go for assuming that they are non-exempt. It is a lot cheaper for your budget to pay somebody some overtime or restrict the person's overtime to control those costs than to have to pay your lawyer and potentially your employee's lawyer for making a bad call or a close call and going the other way and making them exempt when they really are non-exempt, or a judge or a jury decides that they are non-exempt. That's really the most conservative, safest way to go, is just assume people are your employees and assume that they are non-exempt. Another pitfall to watch out for is when you demote employees or put them on a performance improvement plan. If you change their job duties, if you change the focus of their job, then you need to relook at whether this person still meets the exemption. Now, there is case law that says that an exemption is not all just based on what the employee is actually doing, but it's also on what the employer's expectations are of the position. So if the employee is not performing at the level that they are supposed to be because they are not doing the executive level decision making that they're supposed to be doing, that will not destroy the exemption. But if you then tell that employee, well, okay, we're going to strip those duties from you and we're going to have you focus only on these non-exempt functions, then you are destroying the exemption and you have to reclassify them as non-exempt. So for instance, I had one time a client who had a salesperson who was an outside salesperson and would go out and make sales of a particular product. But that person was having some trouble, making sales, meeting their quota. And so they put the person on a performance improvement plan. And as part of that plan, they required the employee to come into the office to make cold calls for a certain amount of time. By doing that, the individual claimed that they now went from being an exempt outside salesperson to being a non-exempt employee. We settled that case. Other things that could destroy the exemption: if you deduct for partial day or partial week absences, you have to receive in order to be exempt, you have to receive a predetermined amount each pay period. You can pay more on top of that predetermined amount, but you have to pay them a minimum of that predetermined amount. The salary cannot be reduced because of variations in the quality or quantity of the work performed. And the salary must be paid without regard to the number of hours or days worked. Now, there are some exceptions which I have listed here, including the first and last week of employment and issues regarding leaves of absences. You can have some partial day deductions for protected leaves, and also for full sick days and full personal days that are taken. Under the FLSA, you can also deduct for violations of written work rules, but you cannot do that in California. And then also for jury and witness duty and military leave, you can deduct for a full week, but you can offset with any fees that they are paid for serving as on the jury or as a witness. Often I get questions about, well, wait a minute, but we have vacation and PTO for our exempt employees. You can substitute paid leave for their salary, but once that PTO or vacation is exhausted, you cannot then start deducting pay from their paycheck because they took 2 hours off on a particular day. The FLSA has a safe harbor provision, but it doesn't help in California, so I'm not really going to go over that. And as I mentioned, you can pay additional compensation on top of the salary, so you can pay bonuses, and you can actually pay your exempt people overtime if you want to. If they worked a particularly very onerous week and you want to reward them for that, you certainly can. That will not destroy the exemption. Also, if you put an exempt employee on an unpaid suspension for less than a full week, that could destroy the exemption for that particular week. And doing things that is contingent upon them working a certain amount of minimum hours, that can also destroy the exemption. So if you require somebody to be in the office for at least 40 hours, you could be destroying that exemption. What you need to be doing is tying it into their performance. and saying you need to complete these duties, and we expect that it's going to take X amount of hours to do that. But if you are amazingly efficient and are able to do it in less time, then you can do that and you will still be paid your full salary. Also keep in mind that an employee cannot release his or her right to overtime pay. So an employee cannot sign a document saying, I agree that I do not, I'm going to release that even though I was owed overtime, that I am not going to get that overtime. Now this is a little bit different than when you have a dispute as to whether somebody is owed overtime or not, and you're resolving a dispute, but that's something that you would want to talk to your counsel about to make sure that the release that you are getting is a lawful release.
Sherry, I'm going to give you
my presentation.
Sherry, I'm going to give you an echo again. If anyone has any questions, please type them in. If anyone has a question, I'll wait for you to type. And I wanted to thank Sherry for giving a great presentation on this important topic. We actually have a prospective client right now that is a firm that does some kind of professional work. I can't tell you what. And we asked them how many employees they had. They said, well, it's me, but I have 11 independent contractors. And I don't believe that they have 11 independent contractors. Hopefully he's on the webinar today. We were hoping he was going to be on it. But I wanted to thank Sherry for a presentation she presented once last year, and our clients and friends of the firm really appreciate the knowledge that she presents. And I will be, we've recorded the webinar, and I will be, as always, we'll be sending out a copy of the webinar or a link to everybody on the webinar. It'll be a private YouTube link. So if you're on the webinar, you'll be able to download the PowerPoint, you'll be able to see the webinar, etc. And if you would like contact information from Sherry, please feel free to contact me and I'll be happy to give it to you. The last thing I wanted to say is that on Wednesday, June 7th, we're going to have another webinar, and that's going to be on the new I-9 form and E-Verify. I went to a PIRA meeting in Burbank a couple weeks ago, and there was a woman there from the Department of Immigration, Department of Homeland Security. She did an absolutely fabulous presentation on new I-9 form and E-Verify and what employers can do, and that'll be on June 7th at 10 a.m. Having said that and seeing no questions, I want to thank everybody very much for attending today. We really appreciate it, and have a great day.